These are appeals in the matter of Orsted West Gunfleet Sands Ltd and the Commissioners for HMRC.
Mr. Jones. My Lords, I appear on behalf of the appellants. My learned friends, Miss Wilson, King's Counsel, and Miss Parry appear on behalf of HMRC. The court should, I hope, have a skeleton from each of us, and then there are 3 sets of files. There should be a core bundle, which in hard copy breaks into 2 volumes. If the court is using an electronic version, then it should be a PDF comprising 673 pages. There is then a supplementary bundle, which comprises 325 pages, and 2 volumes of authorities, which in PDF form comprise 622 pages. As your Lordships will have seen, there are 3 grounds of appeal. They correspond to 3 different headline issues. The first issue is the on the provision of issue, and that concerns whether the various heads of expenditure in question qualified for plant and machinery capital allowances as being expenditure on the provision of plant. As your Lordships will have seen, this was labelled issue 2 before the tribunals below. Ground 2, the second issue, concerns the company's alternative position, which is that if the particular heads of expenditure do not qualify for capital allowances as expenditure on the provision of the plant in question, then the expenditure ought to qualify for deduction as pre-trading expenditure under Section 61 of the 2009 Act. This was labelled issue 4 in the tribunals below. And then finally, ground 3 concerns the question of whether the amounts of qualifying expenditure that were claimed in the returns of 3 of the 4 appellants are to be treated as having been conclusively determined going forward on the basis that HMRC did not actually amend that part of the company's tax returns when they closed their inquiries. And that issue also involves a consideration of the extent of the tribunal's powers under Section 50 of the TMA. That issue was labelled issue 6 in the tribunals below. So I'll deal with the grounds in order, if I may, starting first with ground 1 and the expenditure issue. The factual background to this issue is extensive. I've summarised it, or sought to summarise it, in my skeleton for this court, paragraphs 6 to 12. As your Lordships will have seen, this issue arises in respect of expenditure incurred by the appellants before they determine the size, shape, location and layout of their wind farms, and before they determine the design, size, height and shape of the turbines and the foundations, as well as the location and the pattern of the cables that together comprise the apparatus that generates the electricity in the wind farm. The expenditure in question is expenditure on various environmental surveys, metocean studies, and geophysical and geotechnical surveys that are undertaken at different stages prior to the design, construction and installation of the wind farm out at sea. And as your Lordships will have seen, the first tier tribunal made extensive factual findings, having heard and seen a large amount of evidence. Those findings cover various introductory matters, including the process of developing and constructing wind farms out at sea, what a wind farm comprises in terms of its component parts, and how one operates. And there are also very detailed factual findings in the first tier tribunal's decision, at paragraphs 159 to 211, covering the various reports and studies that relate to the expenditure and the impact of the results of those studies and surveys on the design, construction and installation of the wind farm. Now, in terms of the structure of my submissions on this ground, I propose, first of all, to set out the appellant's positive case on this issue, dealing first at the level of principle, and then seeking to illustrate that principle by reference to specific factual examples of expenditure in this case. And I'll then turn to deal with the decisions of the tribunals below and make my submissions on those. So starting first with the law, and beginning with the statute, where the inquiry begins and really ends, the legislation can usefully be taken from the Upper Tribunal's decision at paragraph 12, which is in the core bundle at tab 9, page 111. If your lordships would prefer to look at it in the authorities bundle, it's tab 1. For convenience, one might take it from the Upper Tribunal's decision. Internal page 2, starting at paragraph 12, section 1, subsection 2A of the 2001 Act provides allowances in respect of capital expenditure, in respect of, amongst other things, plant and machinery. And then section 11 of the 2001 Act sets out the general conditions as to the availability of those allowances. And it provides, by subsection 1, that allowances are available if, under this part, a person carries on a qualifying activity and incurs qualifying expenditure. We're then told what qualifying activity means, or where to find the meaning of that. There is no dispute that the appellants carry on a qualifying activity here. And then, under subsection 4, the general rule is that expenditure is qualifying if it is capital expenditure on the provision of plant or machinery, wholly or partly for the purpose of the qualifying activity carried on by the person incurring the expenditure, and the person incurring the expenditure owns the plant or machinery as a result of incurring it. And the question at the heart of this ground is whether the expenditure on the various studies and surveys which fed in different ways into the design and construction of the wind farm was expenditure on the provision of that plant. Just looking at the statute, in my submission, the section requires one to identify the plant in question and then identify what was spent on its provision. Now, in terms of the first part of that, identifying the plant in question, as your lordships will have seen, in the tribunals below, there had been a prior issue of what was to be taken as the plant for these purposes. The dispute was as to whether the wind turbines and the related cabling, called the inter-array cabling, that joins the turbines up together and then takes it out to the substation, were each to be treated as discrete items of plant, or whether, in the alternative, the entire set of turbines and inter-array cabling as a unit, I think of the way it's described in the FDT decision by one of the experts, is as a single wind power station. It's an aggregate single item of plant. Strictly speaking, that collection of assets has been referred to as the generation assets. They're the parts of the wind farm that generate electricity from the wind. The tribunals below concluded that the correct way to view this was as a whole, so that the plant in question is the wind farm, by which I mean the generational assets, as a single item of plant. That is now accepted by HMRC as being the position. They don't challenge the Upper Tribunal's conclusion on that point. If I might just show the court very briefly in diagrammatic form from one of the documentary exhibits that was before the tribunals below, an example of the array of turbines, so one can...
Sorry, just before we go there, I'm sorry, a little puzzled by what you said. I mean, you said the tribunals below concluded you had to look at the wind farm as a whole, but actually the decision was that it was the so-called generation assets, which were the items of plant.
Yes.
And each generation asset was a single, as I understand it, was a single turbine plus its foundation and linked cabling. So it's a whole lot of assets. It's not the whole farm as a single asset.
Well, so it is. Each turbine is capable of being, in and of itself, an item of plant.
Indeed.
And that was HMRC's position.
Yes.
That is also the appellant's position. But the appellant's position was that the item of plant was the turbines taken together as a single unit, because it was the turbines together in their array which generates the electricity. It's not, they aren't individual items of plant that operate individually. they operate as a whole. And the conclusion of the FTT was that those assets taken together, and it's right to say that they're the generational assets, but what that's referring to is the turbines and the cables that link the turbines together, were together a single complex item of plant. Rather like the dry dock in Barkley Curl, that the dry dock comprised within it items of plant and machinery that were in and of themselves capable of being planned, but the item of plant was the dry dock as a unit.
I mean, nothing may turn on this, and I may have just got the wrong end of the stick on this point, but I got it into my head that what we were having to do was to concentrate on each individual generation asset, i.e. each individual wind turbine plus foundations and cabling.
Well, with respect, my lord, the inquiry is broader than that because, yes, it is true that there are elements, and I'll take the call to them, which focus on individual foundations at individual locations. That's actually quite a striking feature of this case.
Yes.
But that where one is dealing, for example, with amendments to the boundary of the wind farm so that it adjusts the entire array, that is also something which relates to the design of the plant, because the plant is the collection of turbines as a unit. And I wanted to illustrate that with a diagram, if I may, in the supplementary bundle at tab 18, which is page 324. So it's the penultimate page in the bundle. There's a plan view highlighting the west of Duddon Sands site, if your lordships have that. And I don't know how well it comes up in hard copy, but it's possible to see, at least on the screen, there are blue numbers and digits, and they correspond to individual turbines within the wind farm. And then the red dashed line, you'll see on the key on the right-hand side, tells us that that's an inter-array cable. So there's a net of turbines spread out across the site, the intention of which is to capture energy from the wind and turn it into electricity, and it works as a whole. Now, your lordships might note from that...
I see the black square indicates the location of the offshore substation. Where is the black square?
That's
in the
middle. Well,
yes.
I say in the middle, just right of middle, there is something labelled substation.
What I can see, it doesn't look very square, but I should take it that it's square.
Well, it is labelled substation.
Yes, I see.
The
I can see some
clue,
words, yes.
the clue is that all the array cables feed into that as a single point, a single focus, and then the substation links through the export cable, which is the solid red line.
Yes, I follow.
Off back onshore. Now, your lordships might note that the turbine array is not in uniform rows. Whereas, if your lordships look to the top right, there's another site. It's greyed out, but there are other arrays of turbines there, and they are in uniform rows. If your lordships see that. The reason for the distinction that you can see there is that in the middle of the west of Duddon Sands site was found a large amount of igneous rock, into which I'm given to understand it's very difficult to install foundations for wind turbines. Now, that particular physical characteristic of the site was picked up in one of the surveys, the costs of which are in dispute here. But what that does illustrate quite vividly is the way in which the costs in question lead to the ultimate physical layout, the shape of the plant in question. And again, what might be quite helpful about thinking about it in diagrammatical form is that if one has, for example, a change to the boundary of the site, which is necessitated by some factor that's picked up on one of the studies, then you have necessarily a change to the physical characteristics of the plant, because you have a change to the way in which those turbines are arrayed. So that's one example of how the design inputs gathered by the appellants inform the physical characteristics and also the installation of the wind farm. That's all I wanted to say about that diagram. Just to summarise the appellant's case on this issue in outline, and this is the case that was advanced to the tribunals below. First, it is established by authority that the statutory phrase expenditure on the provision of plant in section 11.4a can include more than the cost of the plant or machinery itself. And one sees that in various cases, including two at the House of Lords level, Barkley, Curl and Bedco, which I'll take your lordships to shortly. Those cases establish, and it is common ground, that qualifying expenditure for these purposes is not limited to the bare purchase price or the construction cost of the plant in question. It can include other things, such as transportation of the plant and installation costs. Now, Barkley Curl itself concerned costs related to the construction of a dry dock. By the time the case got to the House of Lords, the parties remained in dispute over whether the dry dock was plant as a whole, and whether the costs of excavating a hole in the ground within which the dry dock was built were qualifying. There was also a dispute about whether the costs of lining the hole that had been excavated with concrete so as to form the dry dock were qualifying. Lord Reid, together with the majority of the House of Lords, held that the dock was plant as a whole and that the costs were qualifying expenditure as being on the provision of plant. And his lordship noted, as we'll see in a few moments, that the plant, which was the dry dock, could not even have been made without the excavation having taken place. And his lordship said from that factual position, he didn't see how expenditure which must be incurred before the plant can be provided can be too remote. It was qualifying. Now, in the present case, the wind farm is a bespoke item of plant. It has to be constructed, has to be fabricated from scratch, and before it can be fabricated, it has to be designed. That is also true of some of its component parts, which had to be fabricated from scratch, from bespoke designs generated from data gathered from the studies carried out at the site. And that is particularly true, as we'll see in due course, of the foundations. As I've already said, it's quite striking that the foundations are bespoke to each individual location of each turbine. They're specific to that square meters, that section of square meterage on the site. And to be designed for that, the companies have to understand the soil profiles and the metocean characteristics at that particular site. Other components within the wind farm weren't bespoke, but they did have to be selected from existing designs, and they were selected based on information that was gathered from the various studies so as to ensure that they were appropriate for the conditions at each site. Now, the appellant's case is that the costs incurred in the process of determining and designing the wind farm's physical characteristics, including those of its component parts, was expenditure on the provision of plant. Because to reason by extension from Barkley Curl, the wind farms could not even have been made until they had been designed. And the costs of doing so were qualifying in the same way that the costs of excavation in Barkley Curl were qualifying. In addition to design costs, the appellants also incurred expenditure in relation to the installation of the wind farm, and that related to studies which informed the appellants as to the safe and effective installation of the wind farm. This ranged from advice as to how to minimise the negative impact of installation on various types of marine life found at the site, to advice as to the location of unexploded ordnance so as to avoid the obvious downside of trying to drive a monopile foundation through an unexploded bomb. Now, I'll come back to installation in more detail in due course. If I could first deal then with the design costs point. I wanted to show you Lordship's 4 authorities, if I may.
Have you moved on from the statute?
Yes.
Can I just ask you this about section 11.4,
Yes.
which has 2 subsections, A and B?
Yes.
And I haven't seen any focus on B, but does one get any colour as to what's meant by expenditure on the provision of plant, by the fact that it also has to be expenditure which leads the person incurring it to own the plant?
I don't know that that particular limb has featured in the analysis of the statutory term on the provision of. I understand that it was introduced subsequent to a case called Guthrie, which was a case, a slightly unusual one, where capital allowances were claimed in relation to the costs of the purchase of a car, which through the fraud of the seller actually was never delivered. And it was held that allowances were available, notwithstanding that the taxpayer never actually obtained a car. Now, that conclusion could not now be reached because of subsection 4b. That's noted in the authorities. I'll show you in due course. But the short answer is that I'm not aware that anybody has taken any colour from limb B in terms of determining what the meaning of limb A is.
Was it there at the time of the various authorities we're going to be taken to?
Yes and no, it depends on the date. I don't have the date for exactly when that limb was introduced.
Guthrie was the 1950s-ish.
I'd have to check. We are going to come in an indirect way to Guthrie, so we can see it through that. But as I've said that in my submission, the correct approach to limb A is to focus on the plant in question. So you do, in the end, have an item of plant that is created and provided, and ask what was the expenditure incurred in that provision. So one starts at the position, if you like, that the taxpayer does own the plant or machinery. But it's not limited to costs of acquiring ownership. And that's recognised at the highest level. So, as the court will be aware, there are 2 landmark decisions of the House of Lords in this area, Barkley, Curl and Benedetto. If I may start with Barkley, Curl, it's in the Authorities Bundle, Volume 1, tab 10. And it's page 79 in the PDF. And as I've outlined, Barkley Curl carried on a trade of building and repairing ships, and it built a dry dock for use in its trade and incurred capital expenditure, which comprised the cost of excavating a specially shaped basin, which had direct access to the River Clyde, and a floor below the level of high tide to enable ships to float in and float out so that they could be isolated and repaired. The expenditure also comprised the cost of lining the excavation with concrete and installing valves and pumps and so on that were needed for the operation of the dry dock. The question for determination was whether the dry dock itself as a whole was planned for the purposes of what was then 279 of the Income Tax Act 1952, and whether the expenditure incurred on excavating the basin to make room for the dock and the expenditure on the concrete lining attracted capital allowances. The majority of the House of Lords answered those questions in the taxpayer's favour. If I may start with the speech of Lord Reed, it begins on page 80. His Lordship begins by describing the dock. I just ask for the purposes of the point that I'll come to to note, please, that between F and G, Lord Reid describes the excavation as preliminary excavation cost. And then at the bottom of page 80, His Lordship summarises the facts found by the Commissioners and says that the dock had to be made at the right level adjacent to the Clyde, and some 200,000 tonnes of earth had to be removed to make room for it. Now, it's worth noting in my submission at the top of page 83, 679 in the report, where Lord Reid summarises the Special Commissioner's decision and quotes extracts from it. The conclusion about the excavation expenditure as being that, in our view, this expenditure was too remote from the provision of the dry dock. It was expenditure on the preparation of land to receive machinery or plant, and as such attracted allowances only under Chapter 1 of Part 10. And Chapter 1 of Part 10 afforded allowances for such expenditure, but at a lower rate than the plant or machinery allowances that the taxpayer was seeking. But the points to note are the reference to the expenditure being too remote from the provision of the dry dock, and also the conclusion that the excavation expenditure was expenditure on the preparation of land to receive the machinery or plant, so emphasising that this was preliminary, it's preparatory expenditure, and the Special Commissioner's conclusion was that it did not qualify. Now, just carrying on page 83, 679 of the report, the taxpayer contended that the whole dock, the entire structure, was plant that was used for the purposes of the trade. And Lord Reid then considers that dispute, that issue, runs from letter B on that page over onto the next page, where His Lordship concludes that the dry dock as a whole was the relevant plant. And then between letters A and B on page 84, says that leads me to the second question, which is the question of the excavation expenditure. Question whether the cost of the excavation necessary to make room for plant is part of the cost of the plant depends on the proper construction of section 2791 of the Act, which is in these terms. The legislation is then set out, and Lordships will note that the statutory words refer to the same phrase as we find in the legislation that's in force today, refers to capital expenditure on the provision of machinery or plant. It's slightly more unpacked in the legislation, but the statutory phrase is the same. And then Lord Reid continues, so the question is whether, if the dock is plant, the cost of making room for it is expenditure on the provision of the plant for the purposes of the trade of the dock owner. In my view, this can include more than the cost of the plant itself, because plant cannot be said to have been provided for the purposes of the trade until it is installed. Until then, it's of no use for the purposes of the trade. This plant, the dock, could not even be made until the necessary excavating had been done. All the Commissioners say, in refusing this part of the claim, is that the expenditure was too remote from the provision of the dry dock. There, I think they misdirected themselves. If the cost of the provision of plant can include more than the cost of the plant itself, I do not see how expenditure which must be incurred before the plant can be provided can be too remote. Now, your Lordships will have noted that the Upper Tribunal in this case considered Lord Reid here to be saying that the excavation expenditure qualified because without it, the provision of plant was incomplete or incoherent. That's the Upper Tribunal's decision at paragraph 120. I'll come back to the Tribunal's decision in due course, but I would just respectfully invite your Lordships to note that that is not what Lord Reid is saying here. The excavation work did not complete the dry dock. What it did was create the hole into which it could be built. As Lord Reid says, the excavation was done to make room for the dry dock to be built. And Lord Guest also refers to the excavation as a necessary preliminary to the construction of the dry dock. That's at page 686 F to G, which I'll come to when we look at his speech in a moment. But it is quite clear that this expenditure was preliminary expenditure, preparatory expenditure, incurred in order to get the land ready to receive the plant. So in that sense, it could be described as expenditure which put the taxpayer in the position to construct the plant. But according to the central reasoning of the Upper Tribunal, such expenditure falls outside the scope of what's qualifying. And yet the majority of the House of Lords in Barkley held that it did qualify. I'd also just like to say something in relation to the passage that I've just read out about remoteness, the concept of remoteness, which is something that HMRC in particular have latched onto in the course of their arguments before the tribunals below and in this court. The special commissioners, as your lordships have seen, refused the expenditure in relation to the excavation on the grounds simply that it was too remote from the provision of the dock. Now, the trouble with that, in my respectful submission, as the Upper Tribunal to a large extent recognised, is that it's a statement of conclusion. It is not a reason. It's really just another way of saying the expenditure doesn't qualify. But whatever the phrase too remote is meant to mean, Lord Reid is clear that expenditure which must be incurred before the plant can come into existence cannot be too remote. And just one final point on this passage of Lord Reid's speech. And this is an important point that I'll return to when we look at the FTT's decision. Lord Reid isn't here saying that only expenditure which must be incurred or which it's necessary to incur qualifies under the section, which is how the FTT seems to have read this passage. All Lord Reid is saying is that such expenditure cannot be outside the scope of what is qualifying. So Lord Reid isn't purporting to define what is qualifying or set a boundary for that term. His lordship's merely deciding that wherever that boundary is, and it's not necessary to decide exactly where the boundary is, and the same is true in this case, the costs are within it. And then moving on in Lord Reid's speech to letter, just above letter F, the revenue in that case also relied on section 300, showing that provision cannot have the meaning which I have ascribed to it. Section is as follows. When a person carrying on a trade incurs capital expenditure on alterations to an existing building, incidental to the installation of machinery or plant for the purposes of the trade, the provisions of this chapter shall have effect as if the said expenditure were expenditure on the provision of that machinery or plant, and as if the works representing that expenditure formed part of that machinery or plant. Here the word used is incidental to the installation of plant. Incidental is a wider word than necessary. In my view, expenditure necessary for the installation of the plant is already covered by section 279. But it may be that the exigencies of the trade require that when new machinery or plant is installed in existing buildings, more shall be done than mere installation in order that the new machinery or plant may serve its proper purpose. Where that is the case, this section enables the cost of the additional alterations to be included. If this section meant that no preliminary expenditure is within the scope of section 279, there would be an anomalous and unreasonable difference between the provision of plant in a new building or in the open and the provision of plant in an existing building. So I do not regard this section as supporting the appellant's argument. And that demonstrates both aspects of the scope of Section 279 as covering installation expenditure, but also includes a reference to preliminary expenditure, i.e. preliminary to the construction of the plant or machinery, and recognition that such expenditure is also within the scope of what is now Section 11. And then finally, in Lord Reed's speech over the page 84, there's a reference to an argument run by the Revenue. Finally, it said, if the cost of excavation is included, why not also the cost of acquiring the land? But the draftsman thought of that. Section 2781A provides that expenditure incurred on the construction of a building is not to include any expenditure incurred on the acquisition of land. The fact that it was thought necessary, or at least desirable, to put in this provision indicates that expenditure incurred on the construction is intended to have a wide meaning. If the cost of acquiring land for the site of a building is excluded, then a fortiori the cost of acquiring land for the site of the plant must also be excluded.
The direct parallel in our case would be the work done on the seabed, actual work done to prepare it for the installation of piles, whatever you call them, for the turbines to be fixed.
Yes.
That would be the exact.
Well, I don't know that there is necessarily an exact analogue. Yes, I would say with respect that's right. Yes.
The difference in Barkley Curl was that they weren't taking a piece of plant and putting it there. They were actually building it in situ.
That's right.
So excavation was part, could be said to be part of installation because it was part of the preparatory work to the seabed to then start building the dock.
Although it wasn't installation in the sense that somebody didn't then turn up with a dry dock and put it in. It was a hole that had to be dug before they could begin to construct what was the plant. The hole itself wasn't plant. It was preparatory work to allow the plant to be constructed. Now, I accept there isn't a direct parallel because digging a hole is not the same as designing plant that has to be fabricated. But reasoning by extension, which is what, in my submission, one has to do in this area because we have certain landmarks, as you do in other areas, certainly in tax, you can see that there are points plotted on the landscape. There is not a clear boundary that's drawn, and there isn't a clear single rule that can be applied. But what one has to do is reason by extension from the authorities that we do have. So I accept it's not a direct parallel, but the key part of the reasoning is that without that excavation, preliminary though it was, the plant in question could not have come into existence. And one can distinguish Bedco, which I'll come to next, because one can't say that about the finance costs in Bedco, which is the argument that the Crown ran in that case. If I may just finish on Barkley Curl briefly, because it is worth looking at the other speeches. Lord Hodson is a speech next. Lord Hodson's in the minority. His lordship concluded, and this is 683H, it's page 87, that the equipment in the dock was plant, but the basin that formed the walls and the bottom of the dock wasn't. It was just a purpose-built set of premises and had the characteristic of a building. So
sorry, I wasn't keeping up. Where are you there?
It's 683H.
I see, yes.
I mean, the punchline is that the dry dock as a whole does not qualify as plant. There are items of plant within the dry dock, but the dry dock as a whole doesn't qualify. And then as to the question of whether the excavation expenditure qualified, Lord Hodson decided, this is right at the end of the speech, it's between C and D on page 88, 684 of the report. His Lordship would allow the appeal on the grounds I've endeavoured to express, so it's unnecessary for me to express an opinion as to the second point, which has been decided in favour of the respondents concerning expenditure on the excavation made to receive the concrete. If the dock is not planned, the appeal as to the expenditure on excavation should succeed also. So that's the extent of the reasoning on that point. Lord Guest's speech is next. Lord Guest was in the majority. And his lordship concluded that the dry dock as a whole qualified as plant. one can see that at 686 of the report. Conclusions set out, or the reasoning runs to letter E, 686. But then as regards the expenditure, that's dealt with then starting between E and F on page 686. It only remains to deal with the second point raised by the appellants, that is, even if the concrete work were planned, the cost of excavation did not qualify under Chapter 2. The Commissioners upheld the contention of the revenue upon this point, their view being that the expenditure was, quote, too remote from the provision of the dry dock. In my view, they were wrong in excluding this expenditure. The excavation was a necessary preliminary to the construction of the dry dock, and in my view was covered by the provision of plant under Section 279. Provision must cover something more than the actual supply. In this case, it includes the excavation of the hole in which the concrete is laid. So again, it's clear from that the expenditure wasn't considered as being something which completed the dry dock, which is how the Upper Tribunal and HMRC seem to have read it. Rather, it was a necessary preliminary to the construction of it, a step that had to be taken before it could be constructed. Lord Upjohn's speech is next. It begins on 687 of the report, page 91 of the bundle. Lord Upjohn was in the minority as regards whether the dry dock was planned, but agreed with the analysis of the majority as regards the costs of the excavation work. So on page 93 of the authorities bundle, at letter C, just above letter C, your lordships will see, my lords, I regret that I cannot agree that the dry dock itself is properly described as planned. And the reasoning for that's then set out. And then on page 94 of the authorities bundle, letters E to F, as regards the excavation expenditure, Lord Upjohn states that he agrees with Lord Reed's analysis and says, 5-6 lines down, if it's proper to regard the concrete work as the provision of plant, it seems to me clear that the Special Commissioners misdirected themselves in concluding that the cost of excavation was, quote, too remote. And for the reasons given by Lord Reed, whose opinion I've had the opportunity of reading, I would agree that this expenditure too was upon the provision of plant and machinery and entitled therefore to initial allowances under Chapter 2. And your lordships might have noted that several of their lordships in this case take the term too remote in inverted commas, what might be referred to today as scare quotes. It does suggest that there's some scepticism on their part as to whether that's even a viable line of analysis. And then Lord Donovan's speech is next. Lord Donovan was in the majority, and his lordship concluded that the plant, the dry dock was a single item of plant, and that holding is at letter G on page 95 of the authorities bundle. And then the consideration of the second question, the excavation cost point, begins at H. As regards the cost of the necessary excavation, I think this comes within the words expenditure on the provision of machinery or plant in section 2791. Again, regarding the dry dock as a whole, similar expenditure incurred in relation to a building or structure is now regarded as expenditure on the construction of such building or structure for the purposes of section 265, subsection 1, without any further or more express provision. And I think rightly so. The appellants say that if a comparable construction be given to the relevant words in 2791 relating to plant and machinery, then section 300 of the same Income Tax Act 1952 would be unnecessary. Just to interject there, that was the point that was dealt with in Lord Reed's speech that we saw earlier. But that section relates to alterations to an existing building incidental to the installation of machinery or plant, and its wording suggests that it was enacted simply as an assurance to remove doubts about a particular kind of case. So Lord Donovan appears to have approached the question as regards excavation from the point of view that the notion of expenditure on the provision of plant or machinery was comparable to the notion of expenditure on the construction of a building, and concluded that the costs of excavation would be included within both. Now, in my respectful submission, that is a useful analogy to draw. It was one that the Upper Tribunal drew, and if one does draw that analogy, then in my submission one would naturally include the design costs of a building within the term expenditure on the construction of a building. Most buildings of any material size or complexity require designing before they can be built, and this is indeed something that HMRC themselves recognise and publicly acknowledge. I'll return to that later, if I may, when we look at the Upper Tribunal's decision. So just to conclude on Barkley Curl, 3 of their lordships considered that the dry dock was planned, and 4 of their lordships considered that the expenditure on the excavation works to allow for the installation or construction of the dock was qualifying expenditure. Now one can contrast that case with the next case, Bedco, which is in the authorities bundle at tab 15, page 160 of the authorities bundle. It was decided around a decade later, and it might be said to show some of the limits of the term expenditure on the provision of plant or machinery. Bedco was a company that was incorporated to acquire and then hire out an oil rig. And before it began to trade, it negotiated large loans that were, for it, essential for the financing of the construction of the oil rig. And those loans carried with them certain costs in the form of commitment fees and interest of around £500,000. The company claimed capital allowances in respect of that expenditure on the footing that it was expenditure on the provision of plant, being the oil rig, under what was then Section 41 of the Finance Act 1971. The Revenue rejected that claim, and that rejection was upheld by the Special Commissioners and the High Court. The case then went on a leapfrog appeal to the House of Lords, where it was decided by a 4-1 majority that the Revenue were correct. Just before we look at the House of Lords decision, could I please just show the Court some aspects of what Mr. Justice Brightman said in the High Court, which is the case at page 160. If your Lordships would move first to page 167 within the authorities bundle, starting at letter J. In my submission, it's worth noting the competing arguments. Counsel for the Crown posed the question, where would one stop once it was accepted that the cost of obtaining finance for acquiring machinery or plant was part of the expenditure on the provision of such machinery or plant, even if, to satisfy the limitations accepted by the taxpayer company, the money were raised for the sole and exclusive purpose and wholly used for the purpose of the machinery or plant in question. Finance can be obtained in numerous ways. And then just moving to the start of the next paragraph, counsel for the taxpayer company would surmount this difficulty by relying on the limitation of remoteness, but I'm not certain that it wholly answers the question. A commitment fee guarantees the provision of the money sought to be borrowed. The expense of underwriting a public issue guarantees that money will be forthcoming. So just to take those two items, there would not seem to be any significant difference. I've selected one way of raising money, but the devices are endless. The case before me is attractively simple because nothing is involved except the commitment fees and interest. Other cases may be far more complicated. On the logic of the taxpayer company's argument, all such expenditure on raising money, however involved the procedure would, I think, have to be classified as expenditure on the provision of the machinery or plant, which is the ultimate object of the exercise. Counsel for the Crown submitted that the Barkley Curl case does not assist the taxpayer company. The excavation of the basin was essential to the creation of the dock. The dock could never have been made without such excavation. The concrete lining wouldn't stand up on its own, nor could a ship get into the dock if the basin had not been made. So the expense of such excavation was essential for the creation of the dry dock, without which it could never have existed at all. The reasoning in the Barkley Curl case he submitted was that the excavation of the basin and the concrete lining thereto were a single entity. The present problem is entirely different, and the same reasoning cannot be applied to the cost of borrowing money. A rig can be built without borrowing money, and the buying price of the structure will be the same, whether the money is borrowed or not. In my respectful submission, that is a useful way of understanding the difference between the two cases and the difference between the two outcomes.
What about the reference to the excavation of the basin and the concrete lining being a single entity?
Well, that's a description of the fact that it is a necessary preliminary, as it's described in Barkley Curl, to the creation of the dry dock, that there is a hole at the right level. It may be that that's a shorthand for the description of that. What was the single entity was the structure that was then built in that hole as an item of plan.
That obviously was the plant. It was the structure that was built that was the plant.
Yes, and the hole was simply preparatory. But the key point that's being driven at there in my submission is that oil rigs can be bought without finance costs, but dry docks can't be built without excavation. And just moving forward to page 169. And this is picking up on the analogy with expenditure on the construction of a building, which also struck Mr. Justice Brightman as being a valid analogy. Page 169, just under letter D, there is one other provision to which I should refer. The Capital Allowances Act 1968, under the heading The Main Release for Capital Expenditure, dealt with industrial buildings and structures as well as machinery and plant. Section 1.1 of the 1968 Act reads, subject to the provisions of this Act, where a person incurs capital expenditure on the construction of a building or structure, which is to be an industrial building or structure occupied for the purposes of a trade, an initial allowance shall be granted. Section 18.1 reads, subject to the provision of this Act, where a person carrying on a trade incurs capital expenditure on the provision of machinery or plant for the purpose of the trade, an initial allowance was to be granted. It seems to me that as a matter of drafting elegance, where one was dealing with the erection of a building or structure, a natural formula would be capital expenditure on the construction of a building or structure. It would perhaps be a little strange to refer to capital expenditure on the provision of a building or structure. Similarly, when dealing with machinery and plant, almost inevitably one uses the words provision of machinery or plant. The words capital expenditure on the construction of machinery or plant would be inelegant. So it seems to me that as a matter of necessary wording, one finds in one case the expression construction of a building or structure, and in the other case provision of machinery or plant. I have difficulty in believing that interest on borrowed money could aptly be described as part of the expenditure on the construction of a building or structure. If one accepts that Parliament did not intend to have a different code in this respect, for dealing with structures and buildings on the one hand and machinery and plant on the other hand in the context of capital allowances, one is led to the reasonable conclusion that the two formulae were intended to comprise the same type of expenditure. An object may qualify not only as a building or structure, but at the same time as machinery or plant. Comparable sections were contained in the Income Tax Act 1952. So again, that picks up on the analogy that seemed to strike Lord Donovan in Barkley Curl between the two types of expenditure there. And then the conclusion at J. The point with which I am concerned is a short one. As said by the Special Commissioners, it is not one that is susceptible of immense elaboration. Having listened to the compelling arguments advanced on both sides, I have reached the view that the argument of the Crown is to be preferred. I think that a distinction is to be drawn, in the context of the present case, between money spent on the provision of finance by the use of which machinery or plant is acquired, and money spent on the provision of such machinery or plant. I therefore decide that the appeal fails. And then, as I had mentioned, the case moves on a leapfrog appeal to the House of Lords, which is the next case in the authorities bundle. Lord Wilberforce gives the first speech. And at page 1095, right at the beginning of Lord Wilberforce's speech, his lordship states the question. At the end of the first paragraph, are interest and commitment fees paid in respect of a loan contracted in order to finance the provision of plant or machinery, capital expenditure incurred on the provision of machinery or plant, that is the whole of the question. The taxpayer was arguing in part that, part of its argument was that the finance costs were part of the costs of the rig in reliance on commercial accounting analysis, which showed that the costs could probably be capitalised on the basis that they were part of the costs of the rig. Now, Lord Wilberforce rejected that argument based on accounting. This is report page 1096, authorities page 174, and the concluding remark is between E and F on that page. Accounting methods adopted by a particular company and other companies might treat similar expenditure differently, cannot determine the construction of statutory words, so that point is rejected. And then over the page, Lord Wilberforce considers then the statutory words and considers them by reference to some case law from other jurisdictions. First, there's an Australian decision, which is said not to be relevant, and then there's a Canadian authority, which is said to be closer to the facts, but critically is based on a differently worded statutory provision, whose policy, in Lord Wilberforce's judgment, was more liberal than the UK statute. And at page 175 in the authorities bundle, page letter H, his lordship states, in considering whether it should be followed and so in effect preferred to the judgment of Mr. Justice Brightman, I bear in mind that it arose under a different statute and one which not only uses a different expression but whose policy as regards deductions seems to have been more liberal than the UK statute. The expression capital cost to the taxpayer, which is in the Canadian legislation, makes it easier to include within deductible expenditure costs which the particular taxpayer incurs. Whereas the UK words more objectively focus on expenditure directly related to the plant. The one draws a line around the taxpayer and the plant. The other confines the limiting curve to the plant itself. Now, I'd ask your lordships to note that Lord Wilberforce refers there to expenditure directly related to the plant. Now that, of course, is itself something of a gloss, albeit from a very authoritative source. It is, in my respectful submission, useful because it helps to convey the fact that the statutory wording covers expenditure on the provision of plant, not simply expenditure on plant. Then over the page, Lord Wilberforce goes on to consider the matter from the point of view of principle and of logic. And then key to this is the part that begins the final paragraph between B and C. An important principle of the law of taxation is that in the absence of clear contrary direction, taxpayers in objectively similar situations should receive similar tax treatment. The taxpayer's argument in the present case does not bring this about. On the contrary, a different result would follow according as he pays for the provision of plant out of his own resources or borrows it. In the latter case, he would get an allowance. In the former, he would not. This may amount to treating an investor worse than a speculator. Moreover, on the same argument, a different allowance in respect of identical plant would result according as he 1, borrows from a bank, 2, raises money by a public issue of debentures, 3, obtains money from his shareholders. And again, a different result would follow according as 1, he's able to capitalise his interest on the money borrowed, or 2, because he's carrying on a profit-making trade or for other reasons, he does not or cannot capitalise it. If the law is such that it offers the taxpayer these options, he is of course entitled to select that which suits him best. But an interpretation which introduces such a large element of subjectivity is to be avoided. The words expenditure on the provision of do not appear to me to be designed for this purpose. They focus attention on the plant and the expenditure on the plant, not limiting it necessarily to the bare purchase price, but including such items as transport and installation, in any event not extending to expenditure more remote in purpose. In the end, the issue remains whether it is correct to say that the interest and commitment fees are expenditure on the provision of money to be used on the provision of plant, but not expenditure on the provision of plant, and so not within the subsection. This was the brief but clear opinion of the Special Commissioners and of the Judge, and little more is possible than after reflection to express agreement or disagreement. For me, only agreement is possible. Now, with great respect, it's not easy to spell out of that a principle of general application in terms of understanding and applying the scope of the words on the provision of plant and machinery. Save perhaps to understand that interpretations of the word which would lead to distinctions of the kind that were identified by Lord Wilberforce there were to be avoided. And what seems in large part to have driven the analysis of the majority in this case is a desire to avoid a construction which gave rise to the difficulties that Lord Wilberforce identified there, which is that different taxpayers could acquire exactly the same plant and could have, depending on the route that they choose to do that, entitle themselves to greater allowances. Now, that is not an issue that arises on the facts of this case, as the Upper Tribunal has identified. There's no suggestion that the costs in question here are not costs that would be incurred by anybody who wanted to install a wind farm out at sea in the way that these four appellants have. So there's no element of subjectivity of the kind that's identified by Lord Wilberforce in that case. Lord Hailsham's speech is next. Lord Hailsham considered that the words on the provision of in the statute were capable of bearing the construction contended for by the taxpayer. That's stated at 177 in the authorities bundle.
Sorry, whereabouts 177?
Page 177, letter F. In my view, the actual words of the statute are capable of bearing either construction according to the context in which they're used. But then it's important to see what precedes that. Just at letter D, it follows that the only question in dispute is whether the fees and interests were items of expenditure on machinery or plant. This depends on whether a narrow or broad construction is to be placed on the words. The appellants contended that the words include all terms properly incurred in the provision of the ocean tide, which is the oil rig, which would include the cost of financing the payment for it. For the respondent, it was argued that the only expenditure on the provision of the ocean tide was in effect its price, and that the commitment fees and interests were not expended on the provision of the ocean tide within the meaning of section 41.1, but on the provision of the money to pay for it, and that for this purpose of the subsection is to be regarded as a distinct and separate operation. In my view, the actual words of the statute are capable of bearing either construction, according to the context in which they're used. But at the end of the day, I agree with the judgment of Mr. Justice Brightman and the view of the Special Commissioners that in the context of section 41.1 of the Finance Act 1971, they bear the narrower of the two meanings, that is, that contended for by the revenue. It follows that, in my view, the appeal should be dismissed. Lord Hailsham then went on to address various cases that have been cited by the taxpayer, including Barkley Curl. It is worth noting in my submission what's said at the top of page 178 of the authorities bundle between A and C. If only to extract from it the confirmation that expenditure on the provision of machinery or plant includes money expended in order to pay for the construction, brackets, or purchase, transport and installation of the machinery or plant itself. There's recognition there that some items of plant can't be bought off the shelf, they have to be constructed. And indeed, it might be said that the cost of designing a bespoke item of plant so that it can be fabricated, actually something that's more intimately related to the provision of plant than the transportation costs, because those costs of designing and then fabricating it are essential to its creation. If transportation costs are included within the scope of the words, then why not the cost of designing the plant so that it can come into existence in the first place? If we are to focus on the plant, then designing it and fabricating it are acts that are more intimately connected with that item than transporting it. Lord Hailsham then summarises his reasoning at F on page 178 of the authorities bundle onwards, and concludes that it's more accurate, in his judgment, and more natural to describe the money as being 5 million spent on the provision of plant and machinery, and 500,000, which is the finance costs, on the loan charges required in order to obtain the money to pay for the plant and machinery. And then in the second place, I favour a meaning to the statute which will provide the same allowance for the taxpayer who meets the cost of an oil rig out of his own accumulated resources, the taxpayer who meets the same cost by a debenture issue or an issue of shares to the public, and the taxpayer who simply borrows the money from a bank or some other source of liquid finance. And then in the third place, I'm not satisfied that the policy of the statute really conforms with the appellant's contention. Granted that its main purpose was to encourage investment in new machinery and plant, I'm not convinced that to include interest charges and commitment fees would serve this purpose without giving rise to abuse. It was agreed in argument that if the constructing company borrowed money in order to finance the construction of the rig and added the interest and commitment fees into the price charged to the purchaser, the total price to the purchaser would rank for first-year allowances. But if the purchaser in his turn borrowed the money to pay for the price containing... but how if the purchaser in his turn borrowed the money to pay the price containing these components? It seems to me that on the appellant's contention, he'd be able to add a second tier of commitment fees and interest. By the time a complicated plant or machinery was ultimately delivered and paid for, there might be more than one, indeed more than two, sets of commitment charges and interest payments included in the ultimate purchase price, and several additional costs of financing the project by the trader to be included in the allowance. And the revenue might be compelled to make to the trader. It is true, of course, that if the appellant's case were conceded, what would emerge would be a coherent and superficially elegant system of taxation in which interest charges before trading would be allowable as first-year capital allowances, and after the commencement of trading would be deductible as expenses in the computation of profits. But I'm by no means certain that this was the intention of the legislature. To qualify for an allowance, the taxpayer must bring himself within the conditions set by the benevolence of Parliament, not convinced the taxpayer has done so in the present case. So again, there is a concern that also appears to have driven in some regard the reasoning of Lord Wilberforce, the conclusion of Lord Wilberforce, that different taxpayers could subjectively obtain different quantum of allowances on acquiring exactly the same item of plant, depending on how they financed it. And then Lord Samand's speech is next. Lord Samand dissented. He was the one in the 4-1 split. And his lordship considered, this is at 1102, above letter B, that the revenues construction of the statutory provision was too artificial and unreal to be accepted. Like Lord Hailsham, Lord Samand considered that the words of the statute were capable of bearing both meanings, but considered that the purpose of the regime pointed towards the taxpayer's interpretation as being correct. And that's expressed at letter D to G. And then there's a consideration of the purpose and the conclusion that that purpose indicated that the taxpayer's construction was correct. But Lord Samand was in the minority of one. Lord Russell's speech is next. It begins on page 183 of the Authorities Bundle. Lord Russell was in the majority, and his reasoning essentially reflects that of Lord Wilberforce. And his lordship, one can see his lordship's conclusion at letter G. The true view, but in my opinion the true view is that the relevant items of expenditure were incurred on the provision of finance and not on the provision of plant.
Sorry, I've lost you on there.
Just below letter G on page 183 of the Authorities Bundle, it's a sentence that begins
Oh,
at
yes,
the
I
end.
see. Yes.
And again, like Lord Wilberforce and Lord Hailsham, one of the points that appears to have weighed heavily with Lord Russell was this concern to avoid the subjective position of the taxpayer from influencing the quantum of allowances. And that was a result that Lord Russell found unattractive. This is page 184 of the Authorities Bundle between letters A and B. Contrast the present case with that of a company with already available assets used to buy the plant. On the appellant's argument, such a company using its already available assets would be relatively disadvantaged in respect of loss of any fruit of such available assets. And then it is also useful to note what's said at the bottom of page 184 at the conclusion of the speech. In my view, the question to be asked is, what is the effect of particular capital expenditure? Is it the provision of finance to the taxpayer, or is it the provision of plant to the taxpayer? In my opinion, the effect of the expenditure was the provision of finance, and not the provision of plant. I would add that I do not seek to confine qualifying capital expenditure to the price paid to the supplier of the plant. I should have thought, for example, that if the cost of transport from the supplier to the place of user is directly borne by the taxpayer, it would be expenditure on the provision of plant for the purposes of the taxpayer's trade. There may well be other examples of expenditure additional to the price paid to the supplier, which would qualify on similar grounds, but such matters are not for decision in this appeal. And then finally, Lord Scarman expressly agrees with the speech of Lord Wilberforce. It's on page 185. So Bedco shows that there are limits to the scope of the term on the provision of. In my respectful submission, it is not necessarily easy to spell out from the reasoning of the majority principles of wider application. It might be said that it is to a large extent a decision which turns on its own particular facts. It is clear, though, that a point that did weigh heavily with their lordships was this concern about taxpayers in subjectively different positions getting different allowances for acquiring exactly the same item of plant. In other words, the quantum of allowances available would depend on the taxpayer's subjective position. As I've submitted, no such issue arises on our facts. The Upper Tribunal, in its decision at 135, said there is no suggestion that the taxpayers are incurring expenditure because of their particular circumstances that other taxpayers in a similar position would not incur.
Would it be fair to say that one point which seems to emerge from Bedco is that the concept of remoteness, however unscientific that may be, is one that judges find quite sort of appealing in this context as a way of trying to express the degree of connection which is sufficient to come within the provision part of the definition.
Well, the only reference to remoteness as a concept expressly that I can recall from the speeches is in Lord Wilberforce's speech, where he refers
wasn't Lord Samand, sorry, Lord Russell himself was using the language, wasn't he? Remoteness. Anyway, sorry, perhaps.
certainly Lord Wilberforce talks about expenditure that's more remote in purpose.
Indeed.
I don't know that Lord Russell expressly uses the term remoteness, but the trouble with remoteness, I think there are possibly two problems with remoteness. One is that it is a concept that is alive and kicking in other areas of the law, which serves a useful purpose. And there might be a tendency to think that it could serve a useful purpose here. The difference, of course, is that in the other area of the law where remoteness is recognised as a concept, there are principles that are applied to govern when something is considered too remote. That is a developed test. There is no equivalent in this area of the law. What makes something too remote? As I've submitted, and as the Upper Tribunal recognised to a large extent, the language of too remote here is just a synonym for not qualifying.
Yes.
And that is just a statement of conclusion. It does not help anyone analyse the position.
And I suspect you'd say the same in relation to the other way that judges seem to be tempted to deal with the point, which is by saying the expenditure was not on the provision of plant, it was actually on the provision of finance.
Quite, and I was going to come on to that, the Upper Tribunal considers, in addition to the point about importance of avoiding subjective distinctions, subjective by reference to the taxpayer's particular position, there's a second line of reasoning one takes from Bedco, which is that you have to focus on what is the effect of the expenditure. Now, that's a slightly different tool, but it's one that requires handling with some care in my submission, because there is a danger that it can be used to confuse a conclusion with a reason. Because it's not difficult to think in any given situation of something which is not planned, that the expenditure could be said to be on. Barkley, for example, was expenditure on a hole, and a hole isn't planned in and of itself, and a hole does not provide plant. There was a debate around this point in the Upper Tribunal which related to Inmarsat, which my Lord Justice Newey gave judgment on. There were launch costs of launching a satellite into space. Now, the report doesn't go into details of exactly what that comprised, but it's not difficult to assume that those launch costs would be extensive, and they would be on things that could individually not be described as planned, like rocket fuel, for example. So if one wants to reach for a conclusion that the thing isn't qualifying, you just look for something in the immediate area of the expenditure and say, it must have been on that, and that isn't planned. So as an analytical tool, it needs handling with some care. It might be said to have a use in probing the analysis or probing the conclusion, but it is not a standalone test, and it's certainly not fail-safe.
I mean, the trouble is, I mean, these are the two leading authorities. They probably are still the two leading authorities, are they? I'm not quite sure how much the later authority really adds. And yes, as you're sort of saying, you don't get a very clear test from them. We know that transport installation, and I think Lord Russell says some other costs might be all right, but quite where the line is drawn is hard to say.
That's right. Now, just one point, that these are, as far as I'm aware, the two leading authorities still, but by analogy with other areas of the law where, as I've said, use the metaphor of landscape where there is a demarcation of certain parts of the scope of the law, we don't have a clear boundary, but we do have indications. Now, they are not all indications at House of Lords level. The two other cases that I wanted to show the court are at High Court level and at FTT level, but they can still be used to help demarcate where the boundary is, because they are conclusions that struck those courts, albeit, of course, not binding on this court, as to where the line can be found, or at least on what side of that line the expenditure in question falls, which is the most that can be expected in my respectful submission.
Yeah.
So the next case that I wanted to show the court is the High Court case of McVey. And that is in the authorities bundle at tab 9. It was a case from 1968. It's page 65 in the PDF bundle. It was a case from 1968 involving a company that printed patterns on wallpapers and on fabrics either by hand using wooden blocks or by machine. And the company bought designs for the patterns to be used on the blocks from artists. And it took advice from its styling committee as to what patterns were going to be put on the blocks. The designs that were purchased but not used were retained on file and were available for reference in connection with work on the production of new designs. The revenue accepted that the wooden blocks themselves that were used to physically print the patterns onto the wallpaper were plant, and that without patterns on them, they would not be complete. They'd be incoherent as items of plant. But the revenue denied that the expenditure on the designs qualified for allowances. It's important to understand how the designs were used on the wooden blocks or in connection with the wooden blocks. And it's for that reason that we've included the tax cases report, because it sets out the Special Commissioner's decision on the facts. And if your Lordships would turn to page 68 in the authorities bundle. Within the case stated, there's an extract of facts at paragraph 6, starting at subparagraph 4. It's just before the line break. It says 45 TC 273. So when wallpaper is manufactured, patterns are printed thereon, either manually or by using hand blocks or silk screens, or mechanically by using machines equipped with pattern-bearing rollers. In the main, the hand blocks, silk screens and rollers are required by the company for its manufacturing activities, are made by its own employees in its own works. The most intricate and expensive part of the work involved in making these items of equipment is that of patterning them. The patterns used for this work are based on designs which have either been acquired by the company from outside freelance artists or produced by artists employed by it who work within its own studios. And then 6, or sub 6, a single original design may include up to 18 different colours. In preparing equipment to print it, whether in the form of patterned hand blocks, silk screens or rollers, it is necessary in the first place to break the design down into a number of patterns, corresponding to the number of constituent colours in the design. Patterns for each such colour are hereinafter referred to as single colour patterns. In making hand blocks, an implement called a ratter is used to get a first impression of the outline of a single colour pattern transferred to the block. The job of gouging out the part of the block of which the pattern is to stand proud is then carried out by a craftsman using hand tools. The job of hand block printing is carried out by manually impressing hand blocks which have been dipped in a tray containing colouring matter onto paper which travels along a belt. So the designs in question, the expenditure on which is in issue in the case, were used to enable patterns to be carved onto the wooden blocks which corresponded to the designs. They weren't, as it seems the Upper Tribunal in this case...
Just for completeness, that's in relation to the hand blocks. What about the silk screens? Is that different?
I don't... the focus on... I would imagine, I think with the patterned, with the silk screen...
I mean, I see that's subparagraph 8.
It's 8. So
I'm not quite sure I've understood the subparagraph 8.
In making the silk screen, silk has first to be stretched on the frames. The design which is to be used is photographed, and films are then made of each single colour pattern in the design. These films are put in contact with sensitised gelatin and exposed to the light, the area not containing the pattern thus being hardened. So I think the idea is that the silkscreen is put through a physical process, which through that process of using the gelatin enables the pattern to be transferred onto the silkscreen so that it can then be used for the printing. But the physical process that's undertaken with the wooden block and with the silkscreen is that the design is, if you like, the blueprint for what is then put onto those items of plant. It is not that the design is simply stuck on. It doesn't complete the plant in a physical sense.
But it's more than looking at a book, for example, seeing the design there and copying it. The pattern, as I read the first sentence of paragraph 7 or subparagraph 7, one is using this thing called the pattern, which is a physical item, isn't it? Using that to to create an impression on the block, which is then gouged out by a toolmaker.
Yes, but that pattern, the source of that pattern, is the design that's brought in. So the designs that are in issue, the expenditure on which is in issue, are bought in.
So what do you mean by the design? Are we talking about a physical thing, or are you talking about a concept of a design?
Well, I think they're bought as physical, a pattern that one can see on a page, in a book. So an artist draws a design. That design is then transferred by means of these processes into the physical, the characteristics of the block or the silk screen. So somebody sees the design, likes it, says, let's make a patterned wallpaper that matches that design. We then have to find a way of making that wooden block imprint that design on the paper. So what they do is transfer, by means of the processes that are described there, an imprint of that pattern onto the block, which is then gouged out. So if you like, it is a plan for the wooden block. It's like a blueprint, like an architect's drawing for a building. It is how this block is going to be gouged out and constructed. It is not the case that the things are bought in and then stuck on a wooden block. They're used to design the wooden block. So they are, if you like, the analogue here would be all of the design inputs that lead to the drawings, which the manufacturers of the foundations turn into steel piles.
It doesn't feel a very close analogy somehow. I haven't quite worked out why. Because what you want in the end is the design.
Well, one has a concept on a piece of paper that is turned into a physical thing. And the turning of it into a physical thing is transforming that concept, on the 2D concept on the page, into a 3D implement that will, when dipped into the ink or paint or whatever is used, will transfer a pattern of that kind onto the wallpaper. I don't say that these are direct analogies, but what one has here is a design cost which feeds into the physical characteristics of the item that is considered to be plant, that the High Court says falls within the scope of the term expenditure on the provision of that plant.
Sanderson's used to be well known and indeed famous for being the main source of buying William Morris designs in the form of wallpapers and things like that. Probably still are.
I think they still do provide those, but the patterns that go onto those wallpapers come from somewhere.
Indeed, I mean they're original designed by Morris himself or members of his factory, probably. It became later in the 19th century. But then we're here concentrating on how you, as it were, translate that pattern into something which can be mass-produced, albeit in this rather bespoke fashion.
The focus of the case is on whether the cost of buying in those designs, which are then transferred by gouging or by the process of converting onto the silk screen a picture, is qualifying expenditure.
Is it different in kind from die? I suppose the die wouldn't be a capital item, but or paint. I mean, suppose you needed a block that was a particular colour, and you went and you took advice on what colour would be appropriate, and then you bought the paint and you applied the paint to the block. Well, you wouldn't say that the paint was other than part of the block, would you? It would be.
Well, I think that's, with respect to comparing two different things. The designs
Well, that's the question.
the designs are a concept. They are used, they are transformed from a 2D design by an artist on the page by the medium of gouging out the wooden block into something that allows that wooden block to print that design onto wallpaper. So the designs are used, but they're used in that conceptual way.
That's the thing. You're trying to make because we've got designs. You're attaching significance to the intellectual effort. But is it, in this context, different in kind from paint? I mean, it happens that it starts with an idea, but it's really just how you apply something to something else to get something that's usable.
Well, the paint is the raw material. It's part of the raw materials that go to make up the wallpaper.
Yes.
The wooden block is the apparatus that allows you to make the wallpaper out of the paper and the paint. So they're the raw materials. The wooden block is the apparatus. To create that apparatus, you need a piece of wood, but the piece of wood has to be patterned. And the pattern for that is created by a tradesperson who gouges physically the face of the wooden block, so that when you print it with the paint, it creates, through relief, the pattern that you desire to be printed on the piece of paper. The plan for that gouging comes from a concept, an artist's drawing. That artist's drawing isn't raw material, and it's not apparatus. The artist's drawing is the concept for the pattern that the design or styling committee would like to have on that wooden block. It is a design input.
Well, so one goes back in the history of art, and you find people like Dürer and so on who do their drawings and also probably make their own woodcuts as well. But there's a similar distinction, I suppose, between the original drawing, which is just a 2D drawing on a piece of paper on the one hand, and the means for mass reproduction of it, for which you obviously need something like, at a very unsophisticated level, a lino cut, and at a more sophisticated level, a carved wood block, or an etching, or all the other means of reproduction.
But if one takes a lino cut, for example, the pattern of the cutting is derived from the artist's drawing.
Yes. Well, unless it's done straight onto the block, of course. It may be, if you're confident enough, you don't need to have you can do it as you go along.
But it's the inspiration for what's going to go on the block. That's the key thing. Now, I don't say that this is a case which is on all fours with our case. But when one is looking across the landscape to see where decisions have gone on points that at least touch on this issue, McVey is a case where, contrary to the Upper Tribunal's conclusion, there are design inputs which do not amount to doing or making. They put the taxpayer in a position to have the plant provided, which on the Upper Tribunal's reasoning would not qualify, which were held to qualify. And that's really the key point. It's not necessarily trying to tease out exactly precise analogies, but the point is that they were not physically used. This is not a physical process, this is an intellectual process. At a step before the fabrication of the plant takes place, which is where the Upper Tribunal and the Revenue say the dividing line is. And beyond, once you step into physical fabrication, that's okay, but anything before that doesn't qualify. And this is an instance of expenditure before that line, which was held to qualify, in my respectful submission, correctly. Now, there were two questions for the High Court. The first question was whether the designs themselves were planned, and the learned judge concludes, it's fair to say with some reluctance, that the answer to that is no, and that was on the basis of authority that was binding on the High Court. One sees this at page 77 in the authority statement. And it's worth, in my submission, just looking at what's said at page 76. This is at the beginning of the judgment of Mr. Justice Cross, second paragraph halfway through. It was conceded by the Crown, if your lordships have that, page 76. It was conceded by the Crown that the wood blocks and the silk screens with the patterns on them are planned, and that the patterned rollers are part of the machines into which they are fitted. It is further conceded by the Crown that wood blocks, silk screens and rollers without patterns on them could play no part in the manufacturing process.
Sorry, I haven't found you. Whereabouts?
So at the beginning of the judgment,
Oh, it's the very beginning.
second paragraph,
Yes, I see.
halfway through, it was conceded by the
Yes,
Crown.
I see. Yep.
Conceded by the Crown that wood blocks, silk screens and rollers without patterns on them could play no part in the manufacturing process and would only be incoherent plant or machinery. Accordingly, the company has been allowed not only the cost of the unpatterned blocks, screens and rollers, but also the cost of patterning them. What is in dispute, as I've said, is the expenditure on the acquisition of designs. So if one is drawing analogies, then it would be the same as the revenue saying here. You can have the cost of the monopile foundations. You can have the cost of fabricating the monopile foundations, but you can't have the costs of anything that goes into the design drawings of the monopile foundations. That's where the line is. What is in dispute, as I've said, is expenditure on the acquisition of designs.
And of course, the point was made rather sharper by the fact that a lot of the designs were never used at all, because as the judge goes on to explain, they wanted to have a bank from which they could make a choice.
Absolutely, my lord is absolutely right, and the judge says, I could see that you might take issue with claiming all of them, but what the revenue is saying is that you have none of them, and that cannot be right. And so, just dealing with the first point as to whether it's planned, the designs themselves are planned. The learned judge holds that he's constrained by authority to decide that the answer to that is no. Second question, can the cost, this is on page 78, the second question is, your lordships have that. Second question is, can the cost of acquiring the design be said to be expenditure on the provision of the blocks, screens and rollers, on which some of them are patterned? If, to take a rather fanciful example, A commissions B to provide him with a patterned wood block so that A may experiment in printing wallpaper with a hand block, B would obviously be entitled to include in his bill the cost of acquiring a suitable design. But counsel for the Crown pointed out that in that case, if one asked B, what are you buying that design for? He would answer, in order to provide A with a patterned wooden block, for which he has asked me. Whereas in this case, if you ask the company's representative, why are you buying these designs, he would not answer in order to provide the company with wood blocks, screens or rollers patterned with them, but would answer in order that the styling committee may have before it a wide variety of designs from which to select a few, which they think are best adapted for reproduction on our papers and fabrics. I feel the force of this argument, but the section itself isolates the provision of the patterned wooden block and poses the question, what did the company spend on it? Just to pause there, this is, in my respectful submission, that is the correct way of approaching the statutory words. You isolate the plant, which here is a patterned wooden block, and then you ask the question, what did the company spend on it? To my mind, it cannot be right to include nothing for the cost of the design. I can well understand it being argued that as so many of the designs are never actually put on any block, screen or roller, only some fraction of the total design cost should be allowed. And I do not think that the Commissioners of Revenue and Guthrie would be an authority against such an argument, for in that case the car would have been used if it had been delivered. But what was argued before me was that not one penny of the design cost should be allowed. To my mind, that cannot be right, and I therefore shall dismiss the appeal. Now, the point is, of course, that the suitable design is an input. Like the wood from which the wood block was made. And without that input, the item of plant, the patterned wooden block, could not have been created. Now, both the Upper Tribunal and HMRC have sought to marginalise this case on the basis that Mr. Justice Cross had not been able to conclude, because of higher authority that was extant at that time, which was later overturned, that the designs themselves could qualify as plant. And the constraint was in Daphne and Shaw, which was later overturned by the Court of Appeal in 1977.
It wasn't technically binding on him, was it? I mean, it was a decision, a coordinate decision by another judge of first instance.
My lord is quite right, but he felt constrained by that authority unless it was overturned by a higher court. So I suppose through
judicial, self-imposed.
Yes, well, judicial
committee
held in the usual way that unless he felt it was clearly wrong, that he would follow it. But that point does not in any way affect the reasoning on the second point, because there is no rule or principle which would mean that expenditure on something which itself could be plant would be precluded from counting as expenditure on the provision of another item of plant. As I have said, many of the individual items that you could identify within the dry dock in Barkley Curl, like pumps and so on, were plant and machinery in their own right, but expenditure on them would have been expenditure on the provision of the dry dock. So there's nothing in that point that infects the reasoning on the second point. It can stand on its own 2 feet. The Upper Tribunal and HMRC are also critical of the brevity of the reasoning given by the High Court. But with respect, the point that expenditure on design inputs for a bespoke item of plant are part of the expenditure on the provision of that plant does not require a great deal of elaboration. This is an area where it is not easy to articulate with great clarity a set of principles which guide the conclusion. But just as in Benedetto, where some, with respect, great legal minds ultimately said this is not a question that admits of great elaboration, ultimately you have to come down one side or the other, the High Court, Mr. Justice Cross, concluded that this was on the right side of the line. And coming back to this metaphor of trying to map out the landscape, this is an authority which shows that design inputs fall within the scope of what is qualifying, contrary to what the Upper Tribunal has held in this case. That was all I wanted to say about McVey. The fourth case that I wanted to show you, Lordships, is the FTT's decision in Samarkand. First of all, the FTT's decision, and then show you briefly what was said in the Court of Appeal. That's the FTT's decision in Samarkand is in Authorities, Volume 1, tab 20, page 244. And again, this is a case not on the capital allowances legislation per se, but I'll explain why I seek to rely on it. And it's another, in my submission, indicator or signpost of where the demarcations are. The facts were complicated, but partners in two partnerships claimed the benefit of loss relief in respect of expenditure on the acquisition of films. And in each case, films were acquired as part of a single transaction, which encompassed their acquisition and associated leaseback in return for fixed and guaranteed rental payments for a 15-year period. Now, whether or not the partners could access the loss relief that they sought depended on a number of conditions being satisfied. And if Lordships would turn within the authorities bundle to page 253, within paragraph 35 of the FTT's decision, the conditions are set out. So the provisions discussed above gave rise to a number of conditions which must be satisfied before a partner in a partnership can claim relief for a loss created by expenditure in relation to the acquisition of rights in a film. Of these conditions, the following were debated before us. They're then set out, but if we just look to the first three, was the partner through the partnership carrying on a trade? If it was the trade one of exploitation of films? If so, was the relevant expenditure, and this is the focal point, incurred on the acquisition of the film, section 130, subsection 3 of Atoya? And it's that particular point that I wanted to draw your Lordship's attention to. It's moving forward in the decision, page 305 of the authorities bundle. This is within the factual findings of the FTT, and just between H and J at para 360. The Lordships have that page. It's page 305. Paragraph 360. Under each, there was an agency agreement between Samarkand and Future, and under each agreement, Future agreed to provide services in relation to the identification, negotiation and recommendation of films and or rights for acquisition and exploitation by the partnership, and the services to be provided were divided between administrative services and agency and consultancy services. And then there's a description of the agency and consultancy services on the following page, and it included identifying and sourcing films for acquisition and assisting the partnerships in agreeing terms for the acquisition and exploitation of the films. And then what follows is a consideration by the FTT as to whether the expenditure on those services was capital in nature or revenue in nature. And the FTT concludes that the costs of identifying films and of negotiating contracts for their acquisition was capital in nature, essentially because they led to the acquisition of a capital asset. And then moving forward to page 309, please. There's a consideration of section 134 of Atoya, paragraph 385. We then asked ourselves, so having concluded that the expenditure was capital in nature, the FTT then considers the provision which will deem the expenditure to be revenue in nature if its conditions are satisfied. So we ask ourselves whether 134 of Atoya meant that even if any of those expenses were of a capital nature, they should be treated as acquisition expenditure and thus of a revenue nature. Section 130, subsection 3 provides that acquisition expenditure is expenditure incurred on the acquisition of the original master version of the film. And section 130 sub 5 provides that references to acquisition expenditure do not include interest or the incidental costs of obtaining finance. Now, just pausing there, the point that I would seek to take from this decision is that there is an analogy between, and a correlation between the wording expenditure on the acquisition of film and expenditure on the provision of plant. And your Lordships will see in a moment that there is a consideration of some of the capital allowances cases that we've just looked at in the context of this discussion about the interpretation and application of those words in section 130. And that 387, Mr. Peacock for the taxpayers says that the specific exclusion of the finance costs by sub 5 was designed to limit the breadth of the type of expense which would otherwise qualify. He says that the decision of the House of Lords in Bedco determined that the finance costs associated with the acquisition of an asset were not an expense on the provision of the asset, but that other expenditure, which is not indirect or remote, such as legal fees and professional costs, would be on the provision of the asset. He says that this is recognised by 130 sub 5, absent which the incidental costs of finance would be deductible. He notes this is consistent with HMRC's practice of treating the legal costs of drafting agreements as costs which qualify for capital allowances, and that for the same reasons the legal costs of agreements to acquire the films would fall within 130 and thus would be treated as revenue in nature. Mr. Talon, for the revenue, draws our attention to Lord Wilberforce's remark in Benedetto that the legislation focuses on expenditure directly related to the plant and draws a limiting curve around the plant. And then there's an extract from the speech of Lord Russell from Benedetto that we had looked at already. And then if we could just skip forward to 393 with the FTT's conclusion, which is over the page on page 310, paragraph 393, we note that 134 is not confined to expenditure on the asset, but applies to expenditure on the acquisition of the asset. The natural meaning of that is to include costs directly related to the acquisition. If we apply Lord Russell's tests, what was the effect of the expenditure? In relation to the cost of negotiating and preparing the agreements, it seems to us that the answer is not that the effect was the production of a piece of paper, but it was the acquisition of an asset. For this reason, we find that expenditure on the negotiation and drafting of the agreement to acquire the films, but not their leasing, would be expenditure on the acquisition of films, and thus deemed to be of a revenue nature. For the same reasons, but on balance, we find that the expenditure on identifying films was expenditure on the acquisition of the films. On the other hand, expenditure in arranging finance for the partners was not, in our view, expenditure on the acquisition of the film. Applying Lord Russell's test, its effect was the provision of finance to the partners, not the provision of a film. In ordinary language, expenditure on getting a mortgage would not be regarded as expenditure on acquiring a house. The exclusion in 135 of interest and incidental costs of finance also makes this clear. We do not regard it as otherwise extending the ambit of 130 sub 3, and then at 398, nor for the same reason was expenditure related to the structuring of the partnership's expenditure on the acquisition of the film. Now, the Samand case went higher, eventually up to the Court of Appeal, but the specific parts of the FTT's decision that I've just referred your lordships to were not challenged on appeal by HMRC. There is just one particular point from the Court of Appeal's decision that I would like to show your lordships briefly, which concerned a related point as to whether the full amount, which was some £8 million, that had been claimed by Samand could be treated as expenditure on the acquisition of the negative of a film in circumstances where the rights were held to be virtually worthless. The Court of Appeal's decision is at tab 22, so that's volume 2 in the authorities. It's page 354.
Is that the Samarkand which I was involved in?
It is, my lord. Yes. So the report should be behind tab 22. It's PDF page 354. And the point that I wish to draw the court's attention to begins at paragraph 100 in the judgment of my lord Sir Launcelot Henderson. It's page 383. So this is dealing with HMRC's cross-appeal in the case, the Queen Quantum issue. Just to summarise it, the FTT had held that the £8 million had not been incurred on the acquisition of a film, but the Upper Tribunal disagreed, although the decision was actually split, and I think it was Mr. Justice Newey, as he then was, exercised a casting vote in favour of the taxpayer, and that was on the basis of an absence of any finding that Samand knew when it paid the money that it was paying for something of no value. And Samand relied before the Upper Tribunal and the Court of Appeal on the decision of the Court of Session in IRC in Guthrie, which is the case that I had mentioned in passing. The Capital Allowances case, which is referred to at paragraph 103, which is on page 385. In support of his second argument, Mr. Finesse relied before the Upper Tribunal, as he did before us, on two authorities. One was the Court of Session in Guthrie, the other was the House of Lords in Stanton and Drayton. And then there's a summary of the facts in Guthrie and the conclusion, and it's noted just between F and G. For present purposes, the important part of this reasoning is the reliance by the Lord President on the fact and object of the expenditure in the absence of any bad faith on the taxpayer's part. The fact that the intended object was not actually realised did not matter under the 1945 Act, but would matter under the modern code governing capital allowances, which includes, in response to the decision in Guthrie, a requirement that the plant and machinery should belong to the taxpayer. So that's the limb B point that we touched on earlier. Now, the ultimate conclusion of the Court of Appeal on this point was to uphold the Upper Tribunal's decision. And specifically, I just rely on paragraph 110, which is on page 387, where my Lord stated, I also find Guthrie of assistance because it shows that in answering the question, what expenditure is incurred on, in a statutory context designed to provide relief for the expenditure, the focus should be on the fact and the object of the expenditure rather than on whether the money was well spent. I agree with Mr. Justice Newey at 119 that no distinction can sensibly be drawn between the statutory language of the relevant provisions in ATOIA, which refer to a person who has incurred acquisition expenditure, which itself means expenditure incurred on the acquisition of the original master version of a film, and the wording in section 15(1) of the Income Tax Act 1945, which refers to a person who incurs capital expenditure on the provision of machinery or plant. Now, the reason I wanted to show the court that passage is because the Upper Tribunal in this case said that it didn't find Samand of assistance because it said that one cannot necessarily read across the term acquisition vis-à-vis legal costs to provision. That's paragraph 149 of its decision. In other words, they seem to have thought that there was an insufficient analogy between the term expenditure on the acquisition of and the term expenditure on the provision of. But the Court of Appeal considered, in my respectful submission absolutely rightly, that there is no real distinction between the two. The Upper Tribunal's second reason for rejecting any reliance on the FTT's analysis in Samand is that the FTT's reasoning was based on a premise that, the FTT's reasoning was based on an assumption, assuming against its own decision, that Samand was trading. And so the Upper Tribunal said, well, the nature of whether you're trading is a question of fact. It's to be answered in the setting of the particular case. And so that means that the FTT's reasoning on the later parts, in particular the parts about what qualifies as expenditure on the acquisition of a film, was based on a premise which was effectively unsound because Samand was not in fact trading. Now, whilst it's true that it is based on an assumption that, contrary to the view it reaches earlier in its decision, Samand was trading, that does not affect any of the reasoning as to the scope of the term expenditure on the acquisition of a film. The parts of the analysis on which I rely don't turn to any extent on the question of whether Samand was trading. So those are the four cases that I wanted to show the court, just in terms of setting out the appellant's positive case, and just standing back from those for a moment. As a matter of principle, I'd submit that expenditure incurred in the design of an item of plant constitutes expenditure on the provision of that plant.
Can we have this again? It sounds like you're going to set up propositions that ought to be written down.
Yes. As a matter of principle, expenditure incurred in the design of an item of plant constitutes expenditure on the provision of that plant. And in this case, the wind farm, and as I've already submitted, to a large extent its component parts, is a bespoke item of plant that must be designed by reference to a number of factors before it can be constructed, installed, and used. And just as the dry dock in Barkley Curl could not have come into existence without the preliminary excavation, so too the wind farm and a number of its essential components could not have been brought into existence until they had been designed and then fabricated. So expenditure on matters and data that feed into that design process can properly be considered part of the costs. Of providing the plant. And the same is true in my submission as a matter of general principle and by analogy with the FTT's reasoning in Samand of matters that directly influence the choice of off-the-shelf components, such as in this case, the turbine units that sit at the top of the tower, which have to be assembled into the turbine to complete the wind farm. The analogy there is with the expenditure on advice as to what film to acquire, which the FTT held was within the scope of the term expenditure on the acquisition of a film. And just to put a bit of flesh on the bones of those principles, if I may, I wanted to illustrate.
Can I just ask
Yes.
where the principle is within all that? Because the first statement as a matter of principle is really your conclusion. As you say in various other cases, what's being stated is really a conclusion rather than an underlying principle. So you state first, expenditure incurred on design constitutes expenditure on the plant. I think the nearest one gets to a principle is your third point, as I've written them down, which is the wind farm could not have come into existence without.
Yeah, well, that's the, my lord is right, but that's the, as I say, the reasoning by extension from the cases that we do have.
I'm not criticising, I'm just trying to understand what the principle is. That the principle you're relying on, which is expenditure on things without which the plant could not have come into existence, constitute expenditure on plant?
Yes, that expenditure which you can identify by extension from what was considered qualifying in Barkley Curl, without which the thing could not be created, without which it could not have come into existence, qualifies as expenditure on its provision. I suppose the more general principle is that design, inputs into design and the design of bespoke items of plant are part of the costs of the provision of plant. at a level of general principle. What I wanted to do was just illustrate that with a factual example from the present case and focus on the geophysical and geotechnical studies. The FTT made extensive findings about this. If your lordships have the FTT's decision, it's in the core bundle, tab 21. Looking first at paragraph 69, which is page 431. Sorry, 433. The geophysical surveys. Have that. Geophysical surveys provide data on seafloor bathymetry, seabed features, water depth and soil stratigraphy, as well as identifying hazardous areas on the seafloor and man-made risks such as unexploded ordnance. They are non-intrusive and involve sensing techniques such as seismic methods, echo sounding and magnetometry. Paragraph 70. Geotechnical investigations which are conducted following geophysical surveys and use the information obtained to target rock, soil, strata boundaries and engineering properties or specific seabed features, ascertain the characteristics of the soil and involve such techniques as core penetration testing, vibrocoring and borehole drilling and laboratory tests. And at 74, page 434, the tribunal records that it was Mr. McCarley's evidence on behalf of the companies that these studies are an absolute prerequisite to the design, engineering, manufacture and installation of the wind turbines, and the data obtained from them directly informs the precise design of each wind turbine and its foundation. The soil profile at each location is one of the primary determinants of the design load of the wind turbine. Each foundation is bespoke to its particular location, and its design is shaped by the data from the geophysical and geotechnical surveys, as well as the metocean surveys. And then there are more specific findings, starting at page 472 in the bundle. It's internal page. So it's 474, internal page 54. Specific findings about geophysical and geotechnical studies. Set out there at paragraph 200. And the tribunal finds, this is subparagraphs 1 to 4, that the first round reconnaissance surveys were designed to get a general impression of the proposed site and were carried out following geological desktop studies. The primary purpose of these investigations was to inform wind farm layout and turbine and foundation design. They also fed into the second round studies, enabling them to be more focused. And then at subparagraph 5, the FTT finds that the first round of surveys was undertaken at the development stage, the second was undertaken in preparation for the manufacturing and construction of the wind turbines and the wind farms. Now, as your lordships may have gathered from the FTT's decision, as might be expected, building an offshore wind farm takes a lot of time, preparation and planning. The work begins many years out from the point of getting the wind turbine spinning to produce electricity. There are many complex steps required before one can get to that stage. So some of these surveys are undertaken several years out or in stages, but they all ultimately lead to the construction of the plant.
And just so I get the context, is this right? You get an allocation of an area at quite an early stage.
Yes.
But it's some years on before you actually decide to go ahead with anything.
Yes, but there are, one has to investigate various things.
Yes.
In order to make that decision, and you get ultimately to what's called the FI, the FID, the final decision to press the button on whether to go ahead with the infrastructure project.
And if we're thinking about geophysical and geotechnical studies, some of them are doubtless before the FID.
Yes, that's right.
And are some of them after the FID?
Some are afterwards. inputs, yes. So they undertake them in rounds. So you have various different rounds. There's the first round, which is described in the findings that I've just taken the court to. So you'll have first round at the development stage, a second round in preparation for the manufacturing construction of the wind turbines. So you have a stage of investigating the soil profiles at the expected location of each wind turbine. And then ahead of, this is subparagraph 6, there's a third round of geophysical and geotechnical investigations.
No, I see. It specifically says after.
After the FID, yes. But just before construction. And the purpose of those is to check whether there are any changes to the shape of the seabed since the first investigation, and get a detailed soil profile for each individual location into which the foundations will be installed, and partly to obtain a final geological data input into the 3D ground model.
I'm not sure this matters at all, but with the earlier stages, pre-FID, presumably one purpose is just to find out whether you want to go ahead at all.
Well, there's an aspect of that, but as the FTT finds, in relation to all of the rounds, they're cumulative. So the data that you take from the first set of investigations is built on for the later investigation. And then at subparagraph 7, the FTT explains that the data acquired from the first two rounds is then evaluated and formed into an input into the overall design basis for each wind farm. The results of these investigations were essential to determining the design and specification of the wind farms, including the foundations. And then, as the FTT explains, that data is interpreted and it's formulated into geotechnical design parameters for the wind farms, and is reflected into what's called a geotechnical evaluation input to design basis. What those documents contain is details of things like soil strength parameters, soil profiles, and so on for each turbine location. Those are the details that have been enabled by the data gathered from the investigations, and they are turned into formula, which then dictate the pile diameter and the wall thickness of the steel for the foundations, because there are various complicated aspects to do with why those things have to be set at within particular parameters for the particular location at which it's to be sited. So, as I've explained, the specific geological conditions for that particular few square meters for each turbine are analysed, and they're converted then into design specifications, so that a foundation that is bespoke to that location can be manufactured. And then there's a reference at subparagraph 10 to the point that I've made when I showed you that plan diagram at the beginning of my submissions, at west of Duddon Sands, about the discovery of igneous rock that resulted in a revised layout of the wind farm, avoiding positions within less than 25 metres of that rock, and a reduction in the number of wind turbines. So there's an illustration of how that feeds into and dictates the physical characteristics of the plant. So you've got information from these surveys that dictate and inform the design and, as a result, then the fabrication of individual wind turbine foundations, but also, when one looks at the wind farm as a unit of plant as a whole, the physical characteristics of that item. Now, the most bespoke component, as I've explained, is probably the foundations, because of the fact that they are designed specifically for where they are to sit. The FTT records at subparagraph 8 that the data is fed into design basis documents. And there's an example that's referred to in subparagraph 11, page 475, of a foundation tender document design basis for Gunfleet. And as the FTT records, there's a statement in that document, this is subparagraph A, that the documents to be used by the foundation designer in connection with the foundation design, including appurtenances, temporary structures, etc., on the Gunfleet Sands II project phase 1, and a further statement that the design basis includes a level of detail sufficient for the detailed design, foundation, design of appurtenances, specification of safety levels, and development of O&M specifications related to assumptions made in the design basis. And then there are sections dealing with various conditions and inputs which dictate the steel structure design parameters, including steel thicknesses, interface levels, and so on. And then at sub 13, with sub 12, the investigations also revealed that seabed conditions meant the design of the foundations needed to be modified, and that the site was very unfavourable for jack-up operations, which is a method of installation. So these surveys also inform how the turbines are to be installed at the site. And then at sub 13, monopile and transition piece primary structure drawings were produced for the wind turbines for all 4 sites. There's a separate drawing for the monopile and transition pieces for each wind turbine, which sets out the dimensions for the monopiles and transition pieces, along with the steel quality which is required for both. If I may, I wanted to just very briefly show you an example of those drawings, just to bring to life the chain, if you like. In the supplementary bundle at tab 18, page 325, final page.
Page 32.
325, it's the very final page in the supplementary bundle. Your Lordship should, I hope, see a picture of some wind turbines standing out at sea. The structure to the left of the picture is the substation, and your Lordships will see some at least one boat. I think there are 2 actually, just for an idea of scale. So this is an array of turbines at west of Duddon Sands, as the label tells us. Now, just taking the wind turbine in the foreground, you've got there, in terms of the component parts, starting at the top, you've got the blades of the wind turbine, which are easy to identify, and then that leads into what's called a nacelle at the top. And then that leads down to the vertical structure, which is called the tower, which is that white cylinder. There are, this corresponds to findings in the FTT's decision about the component parts, although there isn't a diagram in the FTT's decision. So the tower leads down to the gantry, which your Lordships might be able to see. It's that platform where the white bit meets the yellow bit. And there's a ladder there that allows crews to come on and get access to the wind turbine if there's a need to maintain it or fix it if it's gone wrong. And then there's a yellow part that meets the water, and that is the transition piece, the yellow part. And it's so called because it transitions between the tower and the foundation. And then we need to look under the water. And if your Lordships would turn to tab 6 in the supplementary bundle, it's page 133. There's a more detailed diagram of what's going on at the top of the wind turbine. Just moving on to the next page at 134. There's an entry 2.2 support structures. And there's a schematic diagram of what's going on below the waterline. So in that diagram you have the tower then that's cut off at the top of the picture, platform, a boat landing, the transition piece which is coloured yellow on the photograph that we saw, and then sat within that is the monopile. That's the foundation. And that monopile is effectively a steel tube. that's designed to very specific parameters according to the design basis that the FTT has described, which is hammered into the seabed. And then the remainder of the turbine is constructed on top of that. So that monopile is the foundation. There are various different types of foundation one can have. Monopile is just one of them. What is suitable for the particular environment depends on an understanding of the characteristics of that environment, which is partly what's gathered in the surveys. And then in order to build that foundation piece and also the transition piece, the yellow bit, the fabricators need to work from a design. And at tab 5, this is page 131, there is an elevation drawing of a transition piece.
Page 131.
131, yes. So that's the cylindrical transition piece, but in cross-section. It's an elevation drawing of a transition piece from Gunfleet Sands. And it specifies the dimensions and also the type of steel. So this is the drawing that's produced as a result of the design basis document.
But just to understand, if we can, irrelevantly, I see steel quality and that's sort of self-explanatory. THI, MM, any idea what that means?
Where?
MM is millimetres.
Well, I think that's millimetres. I think OD is outside diameter.
I see.
And I think THI is probably thickness.
I see.
And then there's a reference to steel quality. But really, the point is that these are the drawings from which the fabricators take the steel plates and they make the foundations, which will then be driven into the seabed.
This is different for each turbine.
The transition piece is different for each wind farm. So what they'll do is make a transition piece which will be suitable for use with each turbine. They have to figure out what margin is needed to make sure it's suitable for each turbine. The foundation is specific for each individual turbine. And the foundation drawing is on the next page. And it is a drawing for turbine A1. If your lordships look in the bottom right-hand corner, it's Gunfleet Sands Foundations, monopile number A1. So that corresponds to wind turbine A1. And this is a bespoke design for that particular turbine. And in fact, as the FTT found at paragraph 51 of its decision, save for one pair of foundations at the Walney site, every foundation piece in the wind farms in issue in these proceedings was physically unique. So that, if you like, is the factual chain. You have the surveys which gather the data about these various factors that's transformed into a design basis document, which is transformed into these drawings, which is transformed with steel into the item. And in light of that, the FTT went on to find that the geophysical and geotechnical studies, both the first round, second round, and the third round, directly related to what it called the necessary design of both of the wind farms as a whole, and also to the design of the individual wind turbines. That's at paragraph 201, page 476. I have no doubt that the evidence, both oral and documentary, and the findings of fact I have made in respect of that evidence clearly demonstrate that, as submitted by the appellants, the geophysical and geotechnical studies directly relate to the necessary design of both the wind farms as a whole and to the design of the individual wind turbines. This is the case for both the detailed geophysical and geotechnical studies and the reconnaissance studies. I say this for the same reason as to why I found that the expenditure on the detailed Metocean studies qualifies for allowances, and that is a reference for completeness to the conclusion at page 473 of the core bundle, paragraph 196. This is in the context of...
Sorry, which page?
It's internal page 53, paragraph 196. It's core bundle page 473. And the conclusion at 196 in relation to the Metocean studies, which is what the FTC is referring back to, is that without them, the specific design of the turbines could not be undertaken, and so they could not have been fabricated.
And that, of course, feeds into the principles you've been deriving from the authorities.
Well, and that I had intended would illustrate, with a factual example from this case,
Yeah.
the points that I've been seeking to make. That without these inputs, this plant, the wind farm and the turbines, could not have come into existence. And by extension from Barkley Curl in my submission, that means the expenditure qualifies.
And so, just to be clear, here we're concerned with the totality of the expenditure on those studies.
In relation to the geophysical and geotechnical,
Yes.
yes.
And that's probably going to be an appropriate moment. I'll just write that down. In which case, 2 o'clock.